I believe that he's already attempted to answer this question and there was no privilege raised. So he's given a partial answer and now he's about to finish that. So first of all, I don't think it's covered by attorney-client privilege and I'll deal with that if you want me to. But otherwise, he's already answered part of it. So he doesn't get to say, now I'm going to stop. So.
Well, it was a long preface, but I don't think it ever actually got to what might have been at issue there. So if you can lay the foundation, we'll deal with the objection.
Okay. Take a step back. Okay. You realize that an attorney-client privilege is the privilege of the client, correct?
Yes, sir.
And you, in connection with your representation, at least it's been proffered to the court by Mr. Bradley, that it's up to you to decide whether you want to raise the privilege, right?
Yes, sir.
It's not up to Mr. Bradley.
Yes, sir.
So you have the power, in order to get to the truth of the matter, you have the power to waive the attorney-client privilege, do you not?
I believe that's an appropriate question. The privilege is there.
Whether he uses it or not, it doesn't matter why. Mr. Sato, I think if we're trying to get to the answer to your question, let's figure out whether it covers the question you were trying to get to.
And if I may finish, and your position is you have no intention of waiving your attorney-client privilege, correct?
That's correct.
All right, so now, can you answer the question why you waited until November 2nd, the day after you were hired by Ms. WIllis to file for divorce?
I can.
Okay.
So, again, Joycelyn had relocated to Texas, and she had been in Texas for months. She was only here for a brief period of time to drive my daughter's car back with her. And when she came here to do that, I was able to then get her served.
Okay, so your answer as to why you waited until the day after you were hired by Ms. WIllis, which would be November 1st, 2021, to file the complaint for the divorce on November 2nd, 2021. Your testimony under oath is because your wife was here, but had not been here in October, had not been here in September, had not been here in August of 2021.
She had been in Texas taking care of her ailing mother and
your testimony,
an aging father. So the first opportunity that I had after speaking with my lawyers to take care of that was the date it was filed and served, because she happened to be here. It had nothing to do with, that was purely coincidental, that contract.
I understand it's purely coincidence, your testimony.
Yes, sir. And understand that this was by agreement between she and I, she being my wife and I, that we would divorce when the children matriculated out, and that there would actually have been an agreement attached to the filing. It became apparent that the agreement wasn't going to happen, and things got a little contentious. So that's when the privilege will kick in, and I was forced to do it when I did it.
So if I understood correctly, again, you tell me if I'm wrong. Is it your testimony that your wife was not in Atlanta, Georgia, or the metro area throughout October of 2021?
No. In October of 2021, she was back and forth between here and Texas.
So she was, at least on some occasions, in the Atlanta area.
But that was during the time when we were working through the consent agreement that fell through.
Again, I think we're pretty far afield on relevance. The answer to the question about the timing of the divorce filing.
Understood, Ms. Cross. Mr. Sato, where are we going from here?
We're about to finish this area, since I'm not going to be able to go any further about, if we want to call the X, we'll call the X for that purpose.
Well, we might have to discuss whether that's a collateral issue altogether.
No, I'm just saying if. I didn't say we will, but we'll.
Okay.
All right. So you said that you were aware of the contracts that Mr. Bradley and Mr. Campbell had with the Fulton County District Attorney's Office, correct?
Yes, sir.
And how did you become aware of those?
Just through conversation, they
With
told
who?
me,
Conversation with who?
Mr. Bradley and Mr. Campbell.
So you were discussing matters with Mr. Bradley which were not related to attorney-client privilege, correct?
Related to the contracts, yes.
Okay, but you were having conversations that would not, even though, if I understood correctly, Mr. Bradley was your attorney at the time, correct?
At what time?
At the time that Mr. Bradley received his contract from Fulton County, which would have been beginning of January or in January of 2021, right?
Is that the date of his contract?
Pretty close.
I don't know what the date of his contract was, but if
Date
it
for my
was
purpose.
after the date of the filing of the divorce, then yeah.
I'm not talking about after the date of the filing of the divorce. It's been represented to the court that you had an attorney-client relationship with Mr. Bradley from 2015 forward,
Yes, sir.
correct?
Yes, sir. That is correct.
When Mr. Bradley received his contract with Fulton County, that was in 2021, correct?
I don't know.
We can prove that through other evidence. But at the time that Mr. Bradley was doing work for Fulton County, if I understand, you still had an attorney-client privilege, at least you're claiming one, with Mr. Bradley, correct?
Yes.
So when you talk to Mr. Bradley about matters with his contract in Fulton County, those were not covered by your attorney-client privilege, correct?
They were not.
Okay, and that meant that not all communications with Mr. Bradley were covered by attorney-client privilege, correct?
Well, those certainly weren't.
Well, but my question was, not all communications with Mr. Bradley were covered by, at least as you've been represented to the court, by the attorney-client privilege, correct?
Those communications were not.
So there were communications outside of the attorney-client privilege, correct? With Mr.
Yes.
Bradley.
If you're asking me if I ever communicate with him outside of the attorney-client privilege, the answer is yes. I've
Okay.
communicated with him outside the attorney-client privilege.
Let's finish this up. In, did you call it Roman number 4, which is defense? Okay, in defense exhibit number 4, and Mr. Gillen went over with you your responses to certain interrogatories on May the 30th, 2023. Remember that?
Yes, sir.
Not going back into those, the words in the interrogatories are already in evidence, so we're not going to do that. But the ones that we've gone into, there were 2 of them. And your answer to both of those was none, correct?
Yes, sir.
Okay. Now, on January 25th of 2024,
Yes, sir.
you again were in a position that you answered those same interrogatories, the 2 that we're talking about. I can get specific if we need to, but as long as we understand we're talking about the same 2,
Yes,
right?
Sir. Yes, sir.
Okay. And they are in defense exhibit number 6, and they are interrogatories number 4 and number 5.
Okay. Go ahead.
No, I want you to be able to see it. So it's a defense exhibit number 6.
I don't.
So you have 6 up there? I'm told that you have 6.
Okay. Here we are.
Okay. You would agree with me that in defense exhibit number 6, and we're talking about interrogatories of January 25, 2024,
Yes, sir.
that as to interrogatory number 4, that's the same interrogatory, same words that were in the interrogatory that Mr. Gillen went over, which was dated May 30th of 2023, correct?
Yes, sir.
And your original response in defense exhibit number 6 was none, correct?
Yes, sir.
Your updated response was the plaintiff declines to respond to this interrogatory and asserts his privilege pursuant to OCGA section 24-5-505, correct?
Yes, sir.
you know that 24-5-505 breaks down into two privileges, right?
Which is why I was specific. I said I asserted the privacy privilege.
Well, that's what I'm asking you. In your updated response, there's no reference to privacy, correct?
Yes, there is in the code section 24-5-505.
Okay, but it also,
reference to privacy.
just go with me, okay? That code section says, does it not? No party or witness shall be required to testify as to any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness. You'd agree with that, right?
I'm not reading it.
I'm sorry,
I'm not reading it. I don't have it in front of me.
if I may.
We can, I can take judicial notice that is what the rule says if you want to ask him any follow-up questions.
Okay, thank you. You are not claiming that your answer to number 4, interrogatory number 4, on January 25th, 2024, incriminates you, that is, as in Fifth Amendment privilege, right?
That's correct.
You're claiming the second part, that it would bring infamy, disgrace, or public contempt, correct?
I'm going to object to that. I don't think that's the full thing, but and also the witness doesn't have it in front of him, so I don't know how he can respond to that. I think he's heard several times privacy is largely invoked that statutory.
Overruled.
I'm claiming privacy.
The privilege that you make reference to is to infamy, disgrace, or public contempt upon the witness, right? Or party. That's the section that you were relying on, correct?
If that's what it says, yes, sir.
Okay, look. I could show you, but I think the court has already indicated he can take judicial notice of the statute. So you assume that what I'm telling you is accurate, okay?
Yes, sir.
How would an answer of none bring infamy, disgrace, or public contempt upon you?
So as I explained in direct of Mr. Roman's counsel, the minute she elected to intervene into my divorce proceeding, I then started to understand the bigger picture, which was that all the attorneys in the election interference case were colluding with Joycelyn's divorce lawyer. And because of that, I said, privacy. I don't want my divorce proceeding to bleed into this criminal proceeding. I just didn't want that.
So you raised a privilege, if I understand, that indicated that your answer would bring infamy, disgrace, or public contempt upon you, right?
I'm going to object to the relevance of this. It's been asked and answered several times.
Mr. Seda, where are we heading with this?
I think I can finish that up by saying you didn't say none again. You asserted a privilege, correct?
That's correct.
Okay. And you did the same thing, did you not, with number 5?
That's correct.
That is, you didn't say none again, right?
Correct.
Okay. Is the answer to the interrogatory number 4, as you have it in front of you, is the answer none? Is that the truth?
The answer is to that interrogatory is as I placed it at the time I responded, sir.
I'm
That's
asking
the
you
answer.
now, is the answer to that interrogatory
The answer
none?
The answer is still privilege.
So he's apparently electing to apply the same privilege, Mr. Seda, to that exact same question.
And I have a case which indicates that we can get beyond that if the court deems that appropriate.
And to what end?
Hmm?
To what end? Where
That the privilege actually does not apply and he must answer the question.
and where does that get us? Even if he answers the question, hasn't he already kind of said everything he has to say about the nature of the relationship, how long it lasted, when it ended?
No, I think it would prove, I think if he is forced or compelled to answer the question, he will either answer it falsely by saying none, or he answers it truthfully by saying yes, and then telling us what it is. That's what I believe. That's why I'm asking.
But the interrogatory you're referring to, though, the question contained there,
Two interrogatories, yes, sir,
it's the entertaining one, it's whether there were other relationships, right?
with a specific language that's in the interrogatories.
Sure. Haven't you already covered that in all the other questions that we've had so far?
But we have, but again, the court could, if I could require or compel an answer from him as to whether his answer would still be none, then we would know whether or not he was telling the truth. Now, if the answer is no, then obviously there was a time in the past where he was not. It simply requires him to now answer under oath what he refused to answer and claimed, what I might suggest is a bogus privilege, and that you can pierce that privilege because it's a material fact in connection with this case. Again, it's a call that Your Honor makes. I have case law that says you can do that, but it's your discretion.
Ms. Cross?
Your Honor, Mr. Wade's been on the stand now for several hours. He's been asked and answered very personal questions that I believe cover the issues. Mr. Satan was making an argument, and this is probably an argument to make for the later to the court and not a question to propound.
So as I see it, the only relevance these interrogatories have to this case really whatsoever would be as either prior inconsistent or consistent statements. And to that end, I think the question has been put to him again and again and again. He's answered how he believes he felt his answer should be and why he answered a certain way. And as it goes to credibility, I think at this point we're arguing weight. And I don't really see the value in pushing this issue further. So,
All right, well, just for the record, the case that I was going to refer to is State versus Wakefield at 324 Georgia Appeal 587. And specifically, let's see, it would be 590, in which they talk about this specific privilege. This is a 2013 case. And then they footnote to footnote 3. And footnote 3 says, there are times when the materiality of the evidence outweighs the testimonial privilege. And it goes and explains what that is. That's what I'm bringing.
And I see what you're saying, that we could say that you need to answer the question regardless of the privilege you asserted. At this point, though, I think we've covered that ground and we're ready to move on.
Okay. Based on that, I have nothing else. Thank you.
Okay. Mr. McCulloch, anything on behalf of Mr. Floyd? Moving through defense counsel.
Oh, I'm sorry.
No, I'm looking behind you. Mr. McCulloch, on behalf of Mr. Floyd, he's elbowing you, sir. Okay. Mr. Cromwell.
Nothing, Your Honor.
All right. Ms. Cross.
Mr. Wade, have you still got exhibit number 14 in front of you? The one with all of the invoices, I believe.
I believe I have them all.
All right. So you were asked, Mr. Wade, about a couple of the invoice items. And your testimony, I think, was that the percentage of income post special counsel appointment in November 2021, the percentage of your income roughly after that time was about 50-50 Fulton versus other income from your law practice, correct?
Roughly, yes, ma'am.
Sometimes more, sometimes less.
Yes, ma'am.
How about your time? I'm interested in the percentage of your time from November 2021 to, let's say, the close of the special purpose grand jury when it was dissolved in January 2023. You estimate for us the percentage of your time that was spent on Fulton County work versus other work.
Oh, gosh. 99% of the time here in this building working on this case.
All right. It was, as I understood your testimony, it was an intense period in terms of hours while that special purpose grand jury was meeting, correct?
Yes, ma'am.
And who was head or manager of the election integrity case during that time for the district attorney's office?
I was.
You were coordinating the efforts?
Yes, ma'am.
And those efforts included not just the proceedings that were happening in this building, correct?
That's correct.
We don't need to go all through it, but is your representation that 99.9% of the time, let's restrict it to 2022, 99% of your professional working time was devoted to this case?
Yes, ma'am.
And the remainder, whatever it was to some of your other cases that were ongoing?
Yes, ma'am.
2022, I want to focus on that a little bit because if we are looking at, I believe, the financial affidavits, do you have those in front of you as well?
I do.
The financial affidavit that was filed in your divorce case in January 2022, you estimated your monthly income at that time was $14,000 a month, right?
In 22?
January 22.
Yes, ma'am.
January 23, what'd that number come to?
9,000.
What about 2024?
I don't know.
Is that there in front of you? Is that one, that's not one of the ones that's there in front of you?
No, ma'am.
All right. So as reflected in those financial affidavits, your income decreased as a result of your work in this case, correct?
Significant.
The structure of your firm, we talked a lot about that, and I don't want to go through it anymore, but than we need to. But 2022, the structure of your firm changed. Is that correct?
That's correct.
In the early part of 2022, there were three of you. You and Mr. Campbell and Mr. Bradley, you split expenses. Is that right?
That's correct.
And you profit shared among yourselves, correct?
Correct.
After Mr. Bradley left the firm, then there were just two of you, correct?
That is the cause of the significant change. Yes, ma'am.
So now you have two people bringing in income, correct?
Correct.
And one of those people, you, is spending almost all of your time devoted to this election integrity case, correct?
Yes, ma'am.
And your income from this election integrity case is less than what it was the year before.
Yes, ma'am.
We talked about the monthly caps. We didn't talk about it. There was talk about the monthly cap that was included in your contracts, indicating there was a certain threshold that you could reach, number of hours a month. And over that amount, you were not going to be compensated, correct?
That's correct.
All right. And you kind of smile when you said that. That's a little bittersweet there, isn't it?
That's bitter.
All right. Exhibit 14, is that still there in front of you?
It is.
I want you to take a look, please. That's a collection of exhibits that includes all of your invoices as was represented. I want you to take a look at invoice number 9.
Yes, ma'am.
Is that there in front of you?
I have it.
Invoice number 9, Mr. Wade, indicates that you performed hours of work that you were not compensated for because your cap had been reached.
Yes, ma'am.
I want you to take up, and what did you do in those circumstances? When the hours that you worked per month were more than the cap that was in your contract that you were permitted to be paid for?
I was forced to lose that time. I didn't get paid for it.
Okay. And that's what exhibit number 9 shows?
Yes, ma'am.
All right. And in exhibit number 9, you've got a task, hours that were completed, and you just didn't bill for it. You noted the time and then a 0 beside it because you didn't bill the county for that time.
Yes, ma'am.
All right. What about exhibit number, invoice number 13? Can you flip to that for me?
I have it.
Is that a similar situation?
Yes, ma'am, it is.
And what is it on invoice number 13?
This invoice makes me cry. There's so many hours here that I worked that I couldn't get paid for. So.
And you work those hours anyway, Mr. Wade?
Oh, absolutely. This is not the type of job that you could walk away from just because you're not getting paid for it. I think there's some professional rules of responsibility to an attorney who's engaged in a case. You have to see it through. So it's not like I could just throw my hands up and say, well, I reached my monthly cap. I'm done. I can walk away. I can't do that. This is ongoing. It's constant, and I have to do the work.
Can you look at invoice number 23 for me there in exhibit number 14?
Yes, ma'am.
Does that reflect a similar situation, the hours worked that you were not compensated for?
Yes, ma'am.
Invoice number 24 and 27, can you take a look at those and let us know if that reflects the same situation?
Are you trying to depress me?
No,
Look
I'm
at
not.
the money I'm
All right.
It's the same, yes.
Okay. And there's no workaround to that? You didn't attempt to work around that contractual cap on your hours?
Oh, no, ma'am.
All right. You were asked a lot of questions, Mr. Wade, about the affidavit that was submitted, correct? Do you recall those questions?
I'm sorry, I'm stuck on this invoice. You know, if I was going to get a benefit, I'd like that benefit. That's the one I want. That didn't happen.
That didn't happen?
Okay.
All right. And there was no renegotiating your contract to reflect that those hours should be paid, right?
No, ma'am.
Okay. All right. Do you have your affidavit there in front of you?
I do.
The affidavit of course, was attached to and provided in support of the state's response to Mr. Romney's motion, correct?
Yes, ma'am.
And you prepared that affidavit,
I did.
you signed that affidavit.
I did.
All of the allegations and the representations in that affidavit are true. Is that right, Mr. Wade?
Every one of them.
Every one of them. You were asked a lot of questions about our line number 34. Can you turn to that for me, please? It's on page 4 of that affidavit.
Yes, ma'am.
Can you read it out loud for me, please?
The district attorney and I are both financially independent professionals. Expenses for personal travel were roughly divided equally between us. At times, I have made and purchased travel for District Attorney WIllis and myself from my personal funds. At other times, District Attorney WIllis has made and purchased travel for she and I from her personal funds. Examples of District Attorney WIllis is purchasing plane tickets for she and I with her personal funds for our personal travel are attached.
Funds, Mr. Wade. As you understand the term funds, does that include cash?
Yes.
Does that include credit?
Yes.
Does that include reimbursements?
Yes.
You didn't represent in your affidavit, Mr. Wade, that you were including all of the receipts from funds or travel expenses that were paid on your behalf by District Attorney WIllis, correct?
That's correct.
You had, I think your conversation with Ms. Merchant was you produced the receipt that you had.
Yes, ma'am.
Are you aware of any other receipts? Well, I may ask it this way. May I put you on the phone? That's all right. I'm gonna write it on there. I'm gonna mark this as state exhibit number 1. You testify, Mr. Wade, that District Attorney WIllis purchased and funded the entire trip to WIllis. That was her treat to you for a birthday?
Yes, ma'am.
And you testified that she purchased the plane tickets for you, correct?
Yes, ma'am.
And while you may not have had the receipts on hand when you filled out the affidavit, because they weren't in your possession, are you aware now that there are receipts and that it reflects that the district attorney? I've got a copy. Do you remember, Mr. Wade, approximately how much, and that's again, number 1, do you remember how much the flight was for you, your flight to Belize? And if you don't, I'm not tendering it for you, miss. I'm just asking you to take a look at that and see if that refreshes your recollection as to the amount that that plane ticket cost that was extended by District Attorney. You may keep it. You keep it. Does that refresh your recollection, Mr. Wade?
It does. Thank you.
Approximately how much was the amount of the ticket that District Attorney WIllis purchased for your travel to Belize?
$887.35.
And I'm not tendering it, Your Honor, but I will leave it with the court reporter for reference. All right, Mr. Wade. Your testimony here in court today and consistent with your affidavit was that the personal relationship, I think we called it dating today as well, the personal or dating relationship between you and the district attorney began sometime in early 2022, March, I think was your testimony. Is that right?
Yes, ma'am.
And that March date isn't included in the affidavit. The affidavit is less specific, but that was your testimony today?
Yes, ma'am.
And that there was no personal or dating relationship prior to that time, right?
None.
Right. Mr. Wade, I'm sorry. I'm going to direct your attention to 2020. In 2020, were you dating the district attorney?
No,
2020, that was during the COVID pandemic, correct?
it was.
Was there a situation for you, Mr. Wade, that made you particularly vulnerable during the COVID period?
Yes, ma'am. In 2020, and a portion of 21, I was battling cancer. And that prevented me from pretty much leaving environments that aren't sterile. And I had health on my mind.
You were particularly cautious during that time.
Yes, ma'am.
Were you dating anyone in 2020?
No, ma'am.
All right. Thank you, Mr. Wade. That's all I have.
Ms. Merchant, recross on those points only.
Yes, thank you. All right, Mr. Wade, the state asked you about how much money you're making now versus before, and you said you're making significantly less since you've started working for Fulton County, correct?
Well, I did say that, but what we're talking about is because now at this point, the splitting of the financial obligations in the firm are now there are two people carrying the weight of three. So that would scale back on the amount of income, right? Amount of profit.
Well, you're splitting the profits 50-50 though, instead of 1/3, correct?
The profits, yes.
So, but you did testify that you're making significantly less now. We heard about it for a few minutes, significantly less now that you work for Fulton County, right?
Yes.
Would you agree with me that $236,000 is more than $184,000?
Absolutely.
Would you agree with me that $262,000 is more than $236,000?
Absolutely.
All of these years, despite you saying that you were a three-way partner with Wade and Campbell and Bradley, and now a two-way partner with Campbell, all of your corporate tax returns are filed in the law firm of Nathan Wade, though, correct?
My returns, yes, ma'am.
Yes, for your law firm.
Well, for my law firm, because I also have personal returns.
Right, and I'm not talking about your personal returns. I'm talking about your business returns.
Yeah, but the question contemplates that my bring home money is more or less. So I want to be clear that is reflected in my personal returns.
I didn't ask you anything about bring home money, though. I'm not sure what you're talking about.
What I'm talking about is your question was the portion of my testimony dealing with earning significantly less money.
No, my question is I'll just break it down. During 2019, you filed your business returns. I'm not talking about your personal, your business returns for the law firm of Nathan Wade only, correct?
I filed personal and business. Yes, ma'am.
And even though you said you were partners with Bradley and Campbell later on, you filed your business returns not with them, but as a solo practitioner, correct?
I see where we're going. There's a different return for that Wade, Bradley, Campbell entity.
And I'm not asking about that. What I'm asking about is during the years 2019, 2020, 2021, and 2022, you filed a business return for the law firm of Nathan Wade.
Yes, ma'am.
And in 2019, you said that the law firm of Nathan Wade made $184,000, correct?
No, I don't know.
Does that sound familiar? Does that sound about like what you made in 2019 and reported on your taxes as a business law firm?
If that's what's on the return, yes, ma'am, you're right.
Okay, and I'm happy I can bring those up. I've got one copy. I'm not planning on negative tax returns, but okay. All right, may I approach Judge?
Yeah.
Thank you. So in 2019, gross profit for the law firm of Nathan Wade is $184,000, correct?
Let's see.
The second line, number 2, gross profit.
Yes, ma'am. 184, 824. Yes, ma'am.
And then in 2020, you also filed Nathan Wade, attorney at law, and your gross profit was $230,000, correct?
Yes, ma'am.
And in 2021, you also filed as a solo Nathan Wade PC attorney at law, and your gross profit was $236,000, correct?
Yes, ma'am.
And then in 2022, you filed as a solo practitioner Nathan Wade, and your gross income was $262,000, correct?
Yes, ma'am.
I'm not getting into business about your position. But nowhere in these documents do you document that you received cash payments from Ms. Willis, correct?
I don't, I hadn't looked through them. I'd be surprised if there were something in there that said that.
Do you want to
but
look through 'em?
Listen to the answer. I'd be shocked if there was something in there that said that I received some cash from Miss Willis.
Okay. But there is itemized expenditures for travel in here. You did itemize that.
I didn't itemize anything. My
Your accountant itemized it.
I hope so.
But you're responsible for your taxes, even if your accountant files them, right?
I agree.
And so you itemized your expenses for travel on all these documents, but you did not itemize, you didn't put anything in there about you being reimbursed for half of that travel.
Well, those are business returns.
Yes, you
I-
used your business
I
card
would-
to pay for the travel,
Yeah,
right?
but I wouldn't put a personal expense on a business return.
But you
so-
used a business card to pay for these
I use
personal travel.
I use a business card to pay for everything. And what I do is turn over the statement to the accountant, and the accountant then says, okay, this expense, that's personal. We'll put that over here. This expense, that's business. We'll put that over here. And they reconcile it. So you wouldn't find a reimbursement from Ms. Willis on a business return,
Okay, so they're not anywhere there.
nor would you find, well, go ahead.
No, I'm just asking, so there's nowhere for any of that cash to be reconciled there, right?
On the business returns, no, ma'am.
We talked a lot about the financial affidavits. I know the state asked you a couple questions about them. You filed one in 2022. In that one, you stated that you only had $5,000 in cash, correct?
I believe you. Yes, ma'am.
That was sworn under oath.
At the time of the filing, yes, ma'am.
And then in January of 2024, you filed another one that also swore that you only had $5,000 in cash, correct?
At the time of the filing, yes, ma'am.
Okay, so in 2022 and 2024, you only had $5,000 in cash.
At that time, yes, ma'am.
At that time.
And then you also, all of those interrogatories, I'm not going to go through them in painstaking detail, but every single interrogatory you filed, there are 4 of them, all verified ones. Every single one, you said you didn't have any cash stored in a safe, a safety deposit box, or any other location. Plaintiff rarely carries cash. If plaintiff does carry cash, it's a nominal amount, correct?
That's correct.
So we've got what? 2021, you said you don't have cash. 2023, you said you don't have cash. Again in 2023, you said you don't have cash. And then in 2024, you don't have cash, right?
So you're assuming I received the cash and I stored it. I received the cash and I saved it.
Well, you didn't put it in the bank, right?
What's wrong with receiving the cash, Ms. Merchant, and spending it?
Nothing's wrong with it, but
So
you
then
didn't put it in the bank.
that would contemplate why the response is what it is on the interrogatories.
So you spent the cash. That's because before when it was asked, you said you didn't want to disclose where the cash was,
No.
for privacy reasons.
No, well, I said that if I were to store cash in my home, then why would I share that with the world, is what I said. I didn't say that I had some cash stored up in some place, because that's not the truth.
And you've talked a lot about this. I split with a third, I split with half. From the check you received from Fulton County, July 15th, 2022. So all the way back for July 2022, not a single check that you've received from Fulton County has gone into a joint banking account. Every single check has gone into your own personal banking account, correct?
All of them, with the exception of the checks that were going into the WBC firm, went into my business bank account, which is solely in my name.
Right,
I-
your WBC account that you're talking about, that account was closed though in June of 2022.
Correct. So
So
I
everything
would-
after June of 2022 was put in a Nathan Wade bank account, not a corporate bank account with
I'm gonna ask
partners.
for the receipts submitted to-
I think the question right before that only needed a yes or no. So
no, ma'am. The checks were deposited into firm accounts, law firm accounts.
Law firm of Nathan Wade PC
Yes, ma'am.
as a solo practitioner.
Yes, ma'am.
Okay, so they were not deposited into accounts with Campbell or Bradley.
No, ma'am. They were
Okay.
not.
Thank you.
However, there were checks written to Campbell and Bradley that will reflect the third.
And we've tried to get those bank records, but you've objected to those, correct?
You've tried to get what bank records?
We subpoenaed bank records and you've objected to all of those, right?
Your Honor, I'm going to object to the relevance.
It's relevant if he's saying he has all these records, but yet we've tried to get them and he's trying to keep them from us, but he doesn't bring all of the records. And you can make an inference if there's law that says you can make an inference if if some documents are within the party's control and they won't provide them, that there's an inference that they're not positive.
Ms. Cross.
Your Honor, there was no obligation for Mr. Wade to produce evidence that Ms. Merchant couldn't find an admissible way to produce. I believe it's irrelevant. We've covered the ground, and I object to any further questioning.
All right, I'll sustain that. Ms. Merchant, let's find some new ground here.
Okay, thank you. Are you willing to waive your privilege with Mr. Bradley so that he can testify?
I am not willing to waive attorney-client privilege.
Okay, thank you.
Only on the question, the health questions that were asked. And I can ask it from here because we're very. I don't want to get into the type of cancer. I don't want to get into the medical condition itself. Did I understand you to say that you had cancer in the year of 2020?
Yes, sir.
And you explained that because of that, in 2020, you were kept yourself in a sterile environment?
I tried, yes, sir.
Now, what about 2021?
2021, just focusing on my health, trying to get back to myself.
You remember I asked you some questions about Hateville
Yes, sir.
and the condo?
Yes, sir.
And you indicated that prior to November 1st of 2021, you had spent time at the condo, the Hateville condo,
Yes, sir.
with Miss Willis, right?
Yes, sir.
And with someone else? You said Miss Yearty?
Ms. Yurdy, yes, sir.
Okay, so you were not concerned, that was not a sterile environment, was it?
Are you inferring that Ms. Yurdy and DA Willis is not sterile? Of course it's a sterile environment. It's a condo.
But don't you remember then I followed up and said, where else might you have been to show your cell phone records from Hateville? And you said, the airport,
Mhm.
right?
Mhm.
Not a sterile environment though, the airport, you agree?
It is not.
Okay, what about restaurants? Not a sterile environment, right?
They are not.
And the Porsche, you said something about a Porsche what?
Porsche experience.
That doesn't sound very sterile to me. Is that a sterile environment?
You're inside your vehicle.
Yeah, but don't you mingle with others?
You can.
Yeah, and you were doing all that in 2021 before November 1st. That's what you testified to, correct?
Yes, sir.
So there's no reason why you couldn't be dating in 2021, is there?
You mean 2020, Mr. Sato?
No, I said 2021,
All right.
correct?
Dating? No.
No reason.
No reason.
Got it, thanks.
All right, Mr. Gillen? Okay. Mr. Stockton, excuse me.
Just real briefly, you said you started dating in early 2022, and you also used the term personal relationship. And there was no dating, no personal relationship prior to early 22. Is that correct?
Help me understand. I want to make sure I answer you. So let's be clear. 2022 was the start of any intimate sexual relationship with the district attorney.
Okay, and that's what I was wanting to
Okay,
make clear. In your affidavit, you used the term personal relationship.
got it.
Today, you've used the term dating. And your testimony today is that that includes the term basically physical or sexual or intimate relationship. Is that correct?
Yes, sir.
And there was nothing, according to your testimony, there was none of that prior to early 20.
That is correct.
That's all I've got to.
All right, not seeing anyone else. Ms. Cross, any redirect? All right, Ms. Merchant, can this witness be excused?
Judge, we'd ask to keep him under, we might need him to come back after that.
All right, you may step down, Mr. Wade, and please don't discuss your testimony with any other witnesses.
She mentioned subpoena, Judge. Let me just say this. There was an inference made that I was somehow evading service of a subpoena.
We can take that up. I don't think we need to have it on the record in this hearing. Understood, though.
Thank you.
All right, Ms. Merchant, any other witnesses?
Yes, we would call Fani WIllis.
All right, Ms. Cross.
Your Honor, I am gonna object and remove to the motion to quash the district attorney. There's been now lots of testimony from Mr. Wade. I don't believe that there can be for the district attorney to testify as well. For all of the,
All right, Ms. Merchant, what do you think you can establish and have through the testimony of Ms. Willis? And let me stop there.
Conflict in the evidence, Judge. Now that how Mr. Wade has testified, there's a conflict in multiple different issues. I'll go through all the different issues. The first one is the reimbursement issue, the cash. That opens the door in and of itself to Ms. Willis testifying.
Well, what's the conflict there?
That he testified that he didn't have receipts, but we don't know if Ms. Willis has receipts. So that's one issue.
So we don't know. So there's no conflict. We just don't know.
We don't
right?
know. Right?
Okay,
We don't
so it's a
know.
question, not a conflict. But what else do
That
we
is a
have?
question. So, and there's a lot of different issues with different reasons. The first one would be the receipts. Whether or not these cash payments, if there's any payment receipts. The Belize trip, whether or not she paid for the entire thing in cash. Mr. Wade doesn't have knowledge of that. He couldn't remember a lot of things he couldn't remember. So now it goes to Ms. Willis, unfortunately. That he testified that she insists on paying her own way, gave him some cash, that's the quote, some cash. Miami trip, booked it, but thought it would balance out. A couple other trips that we didn't get any information about, Tennessee, Alabama, Georgia, all of those could be financial benefits. We don't know. He didn't know. But he was very vague about that. Yuri, her best friend, testified that it happened in 2019. And now Mr. Wade has testified that the relationship began to become romantic in 2022, I think is where his testimony was. So that is a conflict in and of itself. Right there, that's a big conflict. We've also got more receipts. But the biggest thing about the conflict is when the relationship started. He said he talked with Willis in the conference room after we filed our motion. He specifically didn't use cash, the term cash in the affidavit, but he told anybody who would ask about the cash. And he specifically discussed this and the response. We have a right to go over it.
All right, so you've highlighted the areas you'd like to go into. I think the central question may be, what is it other than, I'm just really curious what she has to say, you have to put on the record. And so that's what I'd like to go through. Ms. Cross?
Your Honor, I think you've identified, Ms. Merchant hasn't itemized inconsistencies for you. She's identified areas of inquiry. The testimony in the record from Mr. Wade is not inconsistent, it's unrebutted. Excuse me. And so that I don't believe, given the testimony of Mr. Wade and the extent of the questioning of him, that there is any reason at this point to go into the district attorney herself. Again, I know the court's read all the pleadings. It really is such a compelling need, is the language of the case law, a compelling need to call opposing counsel. Given the record that's now before the court, I don't believe it's going to happen.
Your Honor, Mr. Dorn, very briefly, Ms. Willis needs to testify. Her best friend or good friend has directly contradicted the declaration that was made by Mr. Wade attached to the government's response. And it wasn't just the declaration of Mr. Wade, it was filed by the district attorney by and through her assistants here. She owns that. And so that affidavit is owned by her, and there are deep concerns that that affidavit is false, and that Ms. Willis knew it was false, and that she needs to come in here if she wants to tell us about the cash. First time we've heard about the cash. Oh yeah, we got cash. Don't have any deposit slips. Don't have any record of it. Maybe Ms. Willis can say, here, all my records where I paid $10,000 in cash back to Mr. Wade. We need to know that. Also, Ms. Willis's financial disclosure. Let's not forget that. We're talking about two people who went to extraordinary lengths to hide their relationship, to hide the nature of their relationship. Extraordinary. The district attorney needs to take the stand, and she needs to tell this court and this courtroom why she filed financial disclosures in 2022, identifying prohibited sources, which Mr. Wade clearly is a prohibited source. Did you get gifts and benefits? Now, we've seen all this. We've seen the trips. We've seen all of the things that total up to around $10,000 in cash. Yet, on the financial declaration for 2021, which was filed in April of 2022, and the financial declaration for 2022, which was filed in April of 2023, there is no listing of any gifts whatsoever over $100 from a prohibited source. It cries out for her testimony. She needs to be able to get up here and say, why didn't you tell on the disclosure form so that people will know the nature of the relationship between prohibited sources and the public official, in this case, the district attorney, who happens to then make a decision to hire someone that ends up being paid hundreds of thousands of dollars, or his firm and him, and none of that is revealed. And the answer is, oh, it's unrebutted. He's explained it's all in cash. Let her get up and let's, and obviously, we are advocates in our position, but that explanation of cash does not pass the smell test or the straight face test. She needs to go on the record. She filed this motion with his declaration. We've seen what happened here. Now, I'll just 2 or 3 more sentences. We need to have the full picture, as we've gotten through Mr. Wade, of his false interrogatory, serious business for a lawyer or anybody. And then suddenly he's changing. She files her financial declarations, same problem. We need her in here to go over all of this and to explain exactly what happened. We would ask the court that the court allow Ms. Willis to be called and interrogated on these matters.
And I would, to Your Honor.
Just a moment, Ms. Willis. So, Ms. Cross, I don't know if you want to speak with Ms. Willis now. It's sounding like maybe they're withdrawing the objection to the motion,
I believe the motion to,
or does Ms. Willis want to take the lead here?
We'll withdraw the motion to quash Ms. Willis based on the. I'm gonna go.
Okay, so the position of the district attorney at this point is that she's no longer contesting the subpoena. Ms. Merchant has called her as the next witness.
I would ask, I need 3 documents in front of me, and they're the 3 filings of Ms. Merchant. 3 filings. Does anyone have the 3 filings of Ms. Merchant? Does the court have the 3 filings of Ms. Merchant?
When you say the filings, you mean like the pleadings?
The pleadings, yes, Your Honor.
Okay, I think we could locate those for you in the supplemental.
I want the one filed on January the 8th, the one filed immediately after we filed ours, and the final one.
If you want to take a break to get them, I can make a copy. I think we have one.
You know, the only copy I have is going to have my notes on it. So if we don't have a clean copy,
have a 5-minute break, John.
Let's
I'll get
take-
the documents.
all right.
I'll sit here and wait for him.
Did we elect someone who's actually making the copy? You got it? Okay. Ms. Cross is yours. Give a tissue.
It's not true that I paid. Here's the-
Thank you, Your Honor. I appreciate the courtesy. They should be here in just a second.
All right, Ms. Cross, you can bring everyone in. Thank you.
Do you swear me, Your Honor?
You want
Do
to
you,
take that?
if whomever would like to.
We got Deputy Scott usually. Let's go, wait a minute, let everyone get situated and then we'll go back on the record.
Yeah, like tissue in here.
All right, we are back on the record. Deputy Scott, if you could swear in our next witness.
I would, and I do apologize. Hannah. Do me a favor. Put 'em on the next one, you can buy it. After you swear me, don't put 'em on the next one. If it's swear, you can go ahead and swear, so I don't hold it before. Yes, sir. District Attorney Fani, Fani. Last name is Willis.
Ms. Willis, how did you know to come into the courtroom right then?
There were people I was pacing in my office,
Okay.
and I heard someone yell, "His testimony is done." It only made sense to me that I would be your next witness, and I've been very anxious to have this conversation with you today. So I ran to the courtroom.
So as soon as you heard that Mr. Wade was done testifying, that's when you just assumed you would be the next witness?
It only makes sense.
Did you listen to any of the testimony?
I've been in my office pacing, ma'am.
Did you listen to any of the arguments?
I did hear the arguments this morning. It's ridiculous to me that you lied on Monday, and yet here we still are. And I did listen to that argument.
All right, so that was it, just the argument, no testimony.
Right, I listened to the argument this morning where Adam Abadi, I thought, did an excellent job pointing out how dishonest you were with the court on Monday. And I'm actually surprised that the hearing continued, but since it did, here I am.
Great. So let's just talk about what you did in preparation for today. Did you meet with Mr. Wade at all? Once the motion was filed, did you meet with Mr. Wade and talk to him about the motion that I filed to disqualify you?
On January this first January motion?
Yes.
I don't know if you could say talked about. I probably had some choice words about some of the things that you said that were dishonest within this motion. So I don't know that it was a conversation. As you know, Mr. Wade is a Southern gentleman, me not so much.
Okay, but my question was, did you have a conversation
I
with
didn't
him?
have a substantive conversation.
You did not.
I read this motion, skimmed it more so, and I've probably said some choice things to him about some of the lies that were told
Okay.
and being printed in the media because, you know, we used to be in a day and time where you had 60 Minutes and people did stories and they verified information and you had this great reporting. But it seems today that a lawyer writes a lie and then it's printed for all of the world to see.
Well, I just want to make sure that you answer the question I asked, though. So my question was,
I'm gonna object, been asked to make.
Overruled, Mr. Abadi.
I told you what happened. I read the motion. I am sure I told him what my opinion of it is.
Okay.
And past that, we had no substantive conversation.
you did not.
Is there
Um,
something you didn't understand?
No, I just wanted to make sure that
Okay.
you did not have a meeting with him in the conference room to discuss the
All
motion.
right, next question,
No.
Ms. Merchant.
So in the conference room of my office within this week, you produced some financial document. That financial document was given to me, something, and I'm not even sure who was giving it to him by me or Mr. Abadi gave it to me. And I think he showed me a document in our conference room. But as far as a substantive conversation, I don't believe I've had any conversation with him that is substantive related to this.
Okay.
I have had conversations with him since you filed the motion, but they wouldn't be substantive to this. He sent me very nice sermons that have been done. And so we've had conversations about, did you listen to that sermon? You know, things of that nature. And I would say they were in relationship to this because I think he did it to be kind.
Let's start back in 2019.
Yeah.
So you and Mr. Wade met in October 2019 at a conference?
That is correct. And I think in one of your motions, you tried to implicate I slept with him at that conference, which I find to be extremely offensive. I stayed at that conference. Mr. Wade was my teacher. I did not meet him when he taught the class. I was standing outside talking to Lisa Reeves, who is a judge. Me and her were just having a conversation. Mr. Wade walks up and they hug each other. They have some brief conversation. She introduces us.
Your Honor, I'm going to object. We kind of thought that when you asked the question, you didn't answer the question, not a speech, so I object to the speech.
I agree,
believe I'm
Judge.
able to explain my answers.
I believe she's able to explain her answer.
And that's,
Ms. Merchant, that's okay. I can handle it. Ms. Willis, I'll ask you just listen to the answer, or excuse me, the question, and keep the answers confined to the question as best you can. I think you'll have more than enough ample opportunity on when the state is
Well,
able to
it's
ask
highly
follow-ups.
offensive when someone lies on you, and it's highly offensive when they try
Judge.
to implicate that you slept with somebody the first day you met with them, and I take exception to it.
All right, well, Ms. Willis, you'll have the opportunity to explain all of that when it's the state's turn to ask more open-ended questions.
Yeah.
Ms. Merchant.
thank you, Judge. So again, my question was, you all met at that conference though, right?
We did the
Okay.
meeting. As I stated, he taught the class. I did not actually meet him when he taught the class. I walked out of the class, and I'm not sure if it was that exact class or we had went to lunch, but we were standing in the vestibule, like outside of the class. Me and Judge Reeves were having a conversation. She had worked at a law firm I worked at back in 1996.
We're getting way afar. I mean, I don't mind her explaining her answers, but I literally just asked if they met at that
She's
conference.
explaining how she met Mr. Wade, which was exactly the question asked by Ms. Merchant.
It was,
These answers are more than appropriate.
Ms. Merchant, if you want more concise answers, perhaps you could lead the witness.
I will. Thank you, Judge. Isn't it true that you met Mr. Wade October 2019
I'm
at
gonna
a judge's
We
conference?
haven't gotten to the point where Ms. Willis should be treated hostily in this situation.
I think we
And
have.
I'm very much want to be here, so I'm not a hostile witness. I very much want to be
Not so
here.
much that you're hostile, Ms. Willis, it'd be an adverse witness. Your interests are opposed to Ms. Merchant's.
Thank you.
Merchant's interests are contrary to democracy, Your Honor, not to mine.
All right, let's
Judge, I
proceed.
would just ask that
We
we,
can keep things moving. Ms.
Thank
Merchant,
you.
next question,
Thank you.
please.
okay, so we've confirmed when you met. After that, isn't it true?
No, I need to explain this, and I think I get to explain my answers. When I met him, Judge Reeves introduced us. He handed me his business card. I'm unsure if I handed him my business card, but we exchanged information. He said, if you ever need any help, give me a call. And he walked to the parking lot.
So after that, you started dating shortly thereafter, correct?
That's a lie. That's one of your lies.
Do you know Robin Yurdy?
I know her as Robin Bryant. I knew her. So Robin did not go to my college. She went to the college of, I went to Howard University. She went to Morgan State. I met her through some people I knew. In college, we hung out a bit, not much because she was in Baltimore and I was in Washington, D.C. But we hung out a bit. After college, I lost contact with her. I probably didn't see Robin again until maybe 7 or 8 years ago, a chance meeting here in Atlanta, but we did not have a consistent relationship from when I left college and came to Emory Law School here in Atlanta. But 8 to 10 years ago, just by happenstance, I ran into her. So she was in Atlanta.
You have been friends with Robin for 30-something years.
Did you hear my answer, madam?
Yes, and I'm asking if you've been friends with her for 30-something years.
I've known her for 30-something years. We certainly hung out and partied together in college. She was from the DC area. She would come home, we'd party together. Wasn't close, but she was certainly in the girlfriends that party together. And then, like I said, I ran into her about 10 years ago in Atlanta, Georgia. But we didn't talk throughout that time period. I didn't see her. I didn't even know where she was. When I ran into her, I was surprised she was in Atlanta. And so, yes, I have known her probably since 1990, 1991, but we have not maintained a consistent relationship that whole time.
For the last 10 years or 5, whatever you'd like to classify it as, have you been friends with her?
I have not spoken to Robin in over a year. I certainly do not consider her a friend now. I think that she, there's a saying, no good deed goes unpunished. And I think that she betrayed our friendship.
So let's narrow it down, the timeline now. So my questions are going to be from the time period of 2019 until she no longer was employed for you, the last time you all talked. So all of my next questions are just focused on that time frame, okay?
Yes, ma'am.
Up until she left your office.
Yes, ma'am.
During 2019, you all were friends, correct?
Yes, we knew each other in 2019.
During 2020, you all were friends, correct?
We were friends during that time period.
During 2021, you all were friends, correct?
Yes.
And such good friends that when you needed a place to stay, you asked her if you could take over her lease.
That's a lie.
You did
That's
not
not
move
the-
into her apartment?
I
or her
did, but
condo?
that's not the way you characterize it is wrong.
I asked if you could take over her lease.
I did not ask if I could take over her lease.
Did you move into her apartment?
I moved into her condo in April of 21. The circumstances around that were that Robin met her husband. They wanted to move into another and separate place. She wanted to get rid of her condo. My father was living with me at the house. Because of this case and because of my stance on gangs, my life was being threatened regularly. My father urged me to leave our home. At the same time, as luck would have it, Robin wanted to give up her lease because she wanted to move in with this new man she met, who eventually became her husband. And so, as life circumstances worked, my dad was begging me to leave the house. He was afraid for me, afraid for his grandchildren. She wanted someone to take over her lease so that she didn't, have to pay a fee or get abandoned. And so I don't remember when, but probably March or April of 21, I moved in and take over her lease.
And did you pay her or did you pay the leasing agent?
No, I don't even know who the leasing agent was. I paid her.
You paid her. Did you pay her cash or did you use a card?
There were some times that I would give her cash, but mostly I paid her via Cash App. That would be the most convenient thing. So I would not only give her her rent, but then like when the utilities would come in, whatever the utility was, she might be like, I need $70, I need $100, whatever it was. And we never had a problem with money. Whatever she told me it was, I never asked to see a bill. I never questioned her. I just gave it to her.
What percentage would you say you paid cash versus Cash App?
Oh, the vast majority was Cash App. I don't know what percentage, I'm not gonna guess that, but the vast majority was Cash App. But there would be times she would say, this bill came in at $70, here goes $70.
Did you have a monthly rent amount that you paid her?
I can't remember. It was $1,400, $1,500. I can't remember what it was. And it would vary, which I don't understand to this day. But like I said, I never questioned her.
When did you
Whatever
move out?
she said it was, that's what I paid.
When did
I
you move out?
abruptly moved out in February, either late January or early February of 22.
Of 22.
Yes,
February
ma'am.
2022, is that what you said?
January, February of
Jan-
22. I believe it is January, but I paid her half the rent of February of 22 is what I remember. And because I was offering to pay the whole rent, even though I didn't live there, I didn't think it was right. And I ended up just paying her half the rent.
So that's after you moved out. You said
Yes,
you
ma'am.
paid her half of that. Okay. And the time that you said you had to move out of your house because you were scared, did your dad stay there at your house?
My father was concerned. Yes, we were both concerned.
Okay. But he remained there.
My father's 80 years old. He would have been 79. He was scared to death of COVID. You have to go back to when this was. My father's an older man. I wanted him to move out. We had some discussions about him moving out, and what he decided was the risk of COVID was more dangerous than the risk of the people that were threatening. Typical man, more worried about his daughter and his grandchildren than his own safety. You'll get to meet him and you'll understand he doesn't scare too easily.
So your grandkids or his grandkids were living at the house as well at that time?
Well, I don't know how old your children are, but when you have adult children, they leave and they come back. They leave and they come back. So there have been periods of time that they're there, they come, they do whatever they want to do. Children do what children do. As long as their mother has a house, they'll come to it. Unfortunately, now the threats because of this case have gotten so extreme. I just pay a mortgage and no one lives there.
And that's what I was going to ask you. So when you moved out in, I think you said April 2021, you left your dad and your two kids at the house?
My dad and my two kids were not at the house.
They
ma'am.
were not. Okay, so they didn't still live at your house.
My youngest daughter certainly did not live there.
Okay.
My oldest daughter would come back and forth. I can't say month for month when she was there or when she was not there. I know that she has been there post me moving out. At this time, no one is at my house.
So at some point after you moved out for the safety reasons, at least one of your children did come
Ms.
back. to the
Merchant, can we
house.
get to either the
Yeah.
relationship or the
Sure.
financial benefit?
Yes. So let's see, we were back at 2021. So you were still friends with Miss Yeardy then. Were you also friends with Mr. Bradley?
I've never been friends with Mr. Bradley.
You've never been friends with Mr. Bradley?
No, I don't consider us to be friends. I don't dislike Mr. Bradley, but I don't consider us to be friends.
Is he someone that you would have in your phone and you would message with?
I might have text messaged him.
Would you text message him and Mr. Wade on the same conversations?
I don't recall doing that, but if it happened, it wouldn't surprise me.
Okay, so that wouldn't surprise you, the three of you. Okay. How frequently would you think that the three of you would have texted?
Not
in a group
very,
chat?
I wouldn't think very often, but you're asking me to recall. I don't even know what time period you're asking me to recall, but I'm not going to speak to that because I just really don't know the answer to that. And so I don't want to speculate as to how often that would happen. But it's not out of my practice to text two people on one text message. So if you told me that happened and showed it to me, it wouldn't surprise me, although I have no recollection of it.
But there would be some record of it in your phone, or the phone records would have some record of those texts.
Perhaps.
Talk about, you said that sometimes you paid Miss Yeardy cash.
I don't
When
think
you
I-
went,
I'm sorry.
when you went on vacation with Mr. Wade, let's just go one by one. Let's start with the first one. What's the first time you went on vacation with Mr. Wade?
I think the first time we went on vacation was around April of 22. And it's a vacation is a stretch, but I'm trying to be comprehensive. I recall April of 22. His birthday is March the 18th. So that would have been his 49th birthday. I took him to like Tennessee for the day. I think we went to a museum. I think we might have stayed the night. I'm not sure. But I mean, Tennessee's kind of hard to call a vacation, but I just am trying to be inclusive. And it, like I said, I know it wasn't more than a day.
So you didn't spend the night.
I think that we did. That's what I'm telling you. I think that there's a possibility that we stayed that night in April of 22.
Who paid for the hotel?
I think I did. It was his birthday.
And would you have used a credit card?
Probably maybe a debit. When I started dating Mr. Wade, it was right around then, that
April 2020?
22, yes, it
2022.
was around then. I don't know, like, you know, it's not like when you're in grade school and you send a little letter and it says, will you be my girlfriend, and you check it. I don't know the day that we started seeing each other, but it was early 22 is my recollection.
Okay, early 22. And you all went to Florida on vacation as well?
I don't recall going to Florida on vacation with him.
You never went to Florida with Mr. Wade?
When we went to get on the cruise ship, we went to Miami.
Okay, that's the only
Um,
time that you went to Florida with him?
I think we went to Miami and spent the night. That's my recollection.
Okay.
I think we spent one night so that we wouldn't miss the ship. That's my recollection of our
Who paid for that hotel?
in Miami. I don't remember that.
And how'd you get to Miami?
We would have flown. And we've done that, so that I'm clear. We've done that twice. I think one time we stayed, and I honestly can't tell you, did we stay when the ship left or did we stay when the ship came back? I also can't tell you. So there's 2 cruises out of Miami. There's one that's in that October time period that was with his mom. And then there was another that was a New Year's Eve trip. I know I paid for the New Year's Eve trip because the tickets were $697 each. And I thought, this is ridiculous that the tickets are $700 to go to Miami. But when you travel during New Year's Eve, you know, they get you.
So let's just back up and talk about the first time that you went to Florida with Mr. Wade. That was the time that you said you stayed in Miami at the hotel the first night?
That's the time I told you, I am not sure. So I'm not sure of 2 things. So I want to make sure that my testimony is clear. I'm not sure if we stayed in Miami on the October trip. I'm not sure if we stayed in Miami on the December trip. I just can't remember that. And I also don't remember, so that the record is clear, I don't remember if the necessity was as we got on the ship or we got off the ship. But I do remember there was a night spent in Miami because either whatever, I don't remember. But I think that there was a night spent in Miami.
That cruise is the one that you took in October, right?
Ma'am, if you have something to refresh my recollection, I'm intentionally trying to not be difficult with you, but I don't want to make up something.
Right.
I know that on one of those 2 trips, we stayed in Miami. I am not sure right now. You're asking me about.
Oh, I'm sorry, you misunderstood. I was not asking you which night you stayed in Miami. I'm asking if you took a cruise in October 2022 with Mr. Wade
Yes, and his mom.
and his mother. That's what I was asking.
Yes,
Is that the first time you met his mother?
yes.
It was on that cruise, and that was Royal Caribbean, I believe?
I honestly don't remember what ship. I know we've taken 2 cruises. I don't know what the ships were.
But he paid for the flight and the cruise on Royal Caribbean that time.
So yes, he paid. He is the original one that does it. He has something called, Mr. Wade is a world traveler. I'm not as versed as him. He's been to 6 of the 7 continents. And so he has both a personal travel agent and he also has a cruise travel agent. I don't know anything about either of those kind of travel agents. So he is the one that would book the travel, but we need to be clear when we're talking about just because he booked it doesn't mean, like, I don't consider him having taken me anyplace. Let me just be honest. The only one that's ever taken somebody someplace is for his 50th birthday. I consider that I took him to Belize, and I took him to Belize because, I don't want to discuss his personal business, but I'm happy Mr. Wade is still here with us. And I did 50 big, very big.
So still on that October Royal Caribbean cruise, even though he had a travel agent, I'm sorry?
If you do me a favor, I don't know what cruise ship, what time. So if you'll help me and say October cruise with mama or the New Year's Eve trip with his sisters, I'll be able to, we
No
can
problem.
communicate. I just don't know what ship.
October cruise with mama. That's what I'm talking about.
Yeah.
He paid for the cruise and the flights for that trip.
Called his cruise agent and he booked that through them because he has a cruise agent.
Right.
He also has a regular agent. I don't know the cruise agent's name.
So I wasn't asking about his travel agent. I was just
Well,
asking
but
if
I'm
he
trying to-
paid for those.
He did not though.
Okay.
Because the reason I consider that he did not is I gave him his money back.
And I was about
So-
to ask that, but initially he paid for that.
Yeah, he called his cruise agent. Like, I think they have his card on record. They do whatever.
So initially he paid for the cruise and the flight to Miami and the Royal Caribbean cruise.
And my understanding of that October cruise is like it was a package the lady did for him.
So, and I'll get to the reimbursements and all that. I'm just trying to confirm he paid for the flight and the cruise in October.
And I think that when you say things that way, I want this record to be
Initially.
abundantly clear that he calls his travel agent, he calls his cruise agent. They do whatever he tells them. He's like on a first name basis with these people. They do it. And then he tells me how much it is and I give him the money back. I don't, just like you're asking me about the money with Robin, I don't do my friends like that. So if you tell me it's a G, then you're going to get $1,000. Whatever it is, I didn't ever make him produce receipts to me. Whatever he told me it was, I gave him his money back.
Isn't it true that he paid for the cruise and the flight on his credit card? I'm not asking about reimbursement or after. He used his credit card to buy the cruise and buy the flight, correct?
I have no idea how he paid for it,
Okay.
if it's a credit card, if it's a debit card, but certainly he called his cruise agent. You know, like how many people have a cruise agent? He calls his cruise agent, tells them where they want to go. They tell him what's booked. You have to remember, he paid for that initial was me, him, and his mother.
And then after that cruise, you all flew to Aruba and spent a couple days in a hotel there, correct?
Right. And his mother was not happy
He
that we left her
initially
behind
paid for that. He initially paid for that.
for Aruba. Yes, ma'am.
So let's talk about both of those. I know he initially paid for it. Did you pay him back?
For the cruise and for Aruba. Yeah, I gave him his money before we ever went on that trip.
You gave him cash before you ever went on the trip?
Hmm.
And so when you got cash to pay him back on these trips, would you go to the ATM?
No, lady.
You would not go to the ATM.
No.
So Fulton County pays you direct deposit, I assume?
Yes, Fulton
Okay.
County and the state of Georgia both pay me direct deposits.
Okay. So the cash that you would pay him, you wouldn't get it out of the bank.
I have money in my house.
You have money in your house. So it was just money that was there.
When you meet my father, he's going to tell you as a woman, you should always have, which I don't have, so let's don't tell him that. You should have at least 6 months in cash at your house at all times. Now, I don't know why this old black man feels like that, but he does. When we were growing up, my daddy had 3 safes in the house. So my father's bought me a lockbox, and I always keep cash in the house. Now, I don't do it to the degree that my father would do it, so he would probably be ashamed with me, but I always have cash at the house. That has been, I don't know, all my life. If you're a woman and you go on a date with a man, you better have $200 in your pocket. So if that man acts up, you can go where you want to go. So I keep cash in my house, and I don't keep cash as good in my purse like I used to. I don't go on many dates, but when you go on a date, you should have cash in your pocket.
So my question was, where did that cash originally come from? If it
I had
didn't
cash
come out of the
from-
bank?
Cash is fungible. We've had cash for years in my house. So for me to tell you the source of when it comes from, when you go to Publix and you buy something, you get $50, you throw it in there. It's been my whole life. When I took out a large amount of money on my first campaign, I kept some of the cash of that. Like, to tell you, I just have cash in my house. I don't have as much today as I would normally have, but I'm building back up now. So you just put money in. It's a very good practice. I would advise it to all women.
So you can't identify when you came into this cash or where the cash came from?
I didn't say I couldn't identify it. No, nobody gives me anything. I am sure that the source of the money is always the work, sweat, and tears of me. What you asked me for is, when did the money go in there? What I am trying to tell you is, so I got divorced in 2005 from my husband.
And
No. It's important. You said, where did the money come from? And I need to tell you where the money came from. And so for many, many years, I have kept money in my house. That money in my worst days has probably only been $500 or $1,000. At my best days, I probably had $15,000 in my house at cash. At all times, there's going to be cash in my house or wherever I'm laying my head.
the money that you paid Mr. Wade, the cash in October of 2022, you do not know where that money came from.
I do know where it came from. It came from my sweat and tears.
You know which job it came from. Did it come from Fulton County or did it come from a private
It
job?
came from, what are you talking about? So it could have come from a private job because before I was VA, I was in private practice. So I earned money during that time period. That's probably in there.
You don't
It
know
could
where.
have, What do you mean? I don't know where it came from. I
I
absolutely.
understand the situation. We can move on.
Okay, thanks. Same with Aruba. You don't know where that cash came from either, right?
Ma'am, you are mischaracterizing my testimony greatly. I'm not going to allow you to mischaracterize my testimony. I know that I keep money in my house. The amounts of money I gave Mr. Wade, it was never that serious. I don't think I've ever handed him more than $2,500 in a reimbursement. So we're not talking about $20,000 in cash. I don't have $20,000 in cash right now. The most I ever gave him, I know I gave him $2,500 when we went to Belize, because we went to one hotel and then we went to a second hotel. That $2,500 I actually gave him while we were still in Belize. I know that the Aruba trip, the one that you described with his mom, I think I gave him about $2,000 for that trip for like total.
His mom went to Aruba with you?
The Aruba trip. So I consider that to be one trip. So we got off of a cruise ship and then we went to Aruba, which is why I cannot remember is that the time that we had to stay in Miami to wait for the flight for Aruba. So I consider that one trip that we didn't like come back to Atlanta and leave. We flew down to Miami. We got on a cruise ship. We spent a couple of days with his mama. We came back to Miami. When we came back to Miami, either that day or the next day, we flew to Aruba. We spent a few days in Aruba and we came back. That was really one trip. Even though we went two places, it was one trip.
So let's talk about the California trip.
Now,
Is that when you were moving your daughter out to California? When you all went, or did you have two trips to California?
my daughter doesn't live in California.
Did she ever live in California?
I'm not discussing to you the location of my child.
So how many times did you go with Mr. Wade to California?
Once.
And you all stayed in Napa Valley and he paid for the plane tickets and the hotel?
He paid for the plane tickets and the hotel.
And what did you pay for on that trip?
I gave him much less cash that time, probably $400 or $500, and then I paid for a bunch of stuff. I think we did 2 different wine tours that you do, which are pretty expensive. I think I bought him. He likes wine. I don't really like wine, to be honest with you. I like Grey Goose. I bought him a bottle of wine while we were there, and the sippings that you do. I can't remember how many, like 4 or 5 different places you go. I remember we went to this place that they do pairings. That was the most expensive thing that I think that we did while we were there. So they would pair champagne, chocolate, and caviar. It was a 3, and it was like 3 different things: Sweden, Russia, someplace else. I'll make that up. But that was the most expensive thing we did that trip, and I paid for that.
You pay cash?
For us doing that?
Mhm.
Yeah, that trip did not cost me a lot of money. I might have took like $750 in cash on me because we weren't gone very long. And then
I'd only asked if you paid in cash. I don't need to know the amounts.
when I travel, I always take cash.
And is the cash that you keep in your house, or do you keep it at the condo that you were living in?
So at that point, it wouldn't be at my house, and I'm sorry if I was not clear. The money would be wherever I laid my head. So I wouldn't leave the money at the house. So if I was unclear, no, money's gonna be where I stay.
How much did you pay for your trip to Panama?
To where?
Panama, I believe.
I didn't go to
I
Panama.
may have the location wrong.
I never went to Panama.
So
Mr.
after
Wade went to Panama with his frat brother.
Oh, he went to Panama with his frat brothers. So tell me about, let's see. So I want to make sure I've got them. I've got Belize.